Okay, our next tutorial is tutorial number 2 for this course. I like to say hello to all of you. Say hello to all of you. Hello, Bula. Okay, now we will look at our second tutorial. This is the second one. This, concerns presentations I made dealing with PowerPoint 6, 7, and 8. And in this tutorial also I have captured some videos that you will also play and listen for improving, your understanding for purposes of, facilitating this learning by way of this video tutorial. So I hope the video that I have also captured in this tutorial will assist in a big way. All right, now the first part of the question is something to do with most favored nation. All right, what is most favored nation? All right, most favored nation. Most favored nation, as you can see, all right, is to deal with certain treatment that member countries give to other member countries. All right, most favored nation treatment. It's not a new topic. All right, it's not a new topic. There have been a lot of discussions. There have been a lot of discussions in writing. There have been a lot of commentaries. There have been a lot of scholarly work on it. There have been a lot of oral, presentations, oral debates in various forums on most favored nation treatment. And since WTO came into being, WTO and GATT 1994. Now, GATT 1994 is the result of the failure of the previous GATT, and also when International Trade Organization was not able to function, came the Uruguay round negotiation, which gave birth to GATT 1994, and of which WTO was established. WTO is more an administration body that looks after, that administers GATT. GATT is to do with General Agreement on Tariffs on Trade. So in GATT we have this one of the fundamental principles concerning treatment given to all the WTO members when they trade, when they do business, when they when they import and export amongst themselves. So what it is that the most favored nation treatment, it requires members to accord, or if not, give the treatment, the most favored nation treatment, favorable treatment to all the members that they trade with. There should not be discriminatory practice where one member gives a favorable treatment to another member of WTO. That favorable treatment must be accorded to a third or fourth or fifth member countries. There should not be favoritism. That's basically what it is. There should not be favoritism in terms of one member dealing with rest of the members, favoring one member of WTO and then less favoring the other member, or become discriminatory in the practice of trade amongst themselves. So as you can see in the WTO or in the GATT, the article, that concerns FNN treatment, most favored nation treatment, it doesn't allow for discriminatory practice among the WTO members. Now, in the readings that I posted online, dealt with in depth, in terms of WTO, in terms of most favored nation treatment, MFN treatment, next. Right now, let's listen to the video, of which the video will deal with most favored nation treatment in a way that will help you to understand more about this concept. So I'm playing the video.
In international economic relations and international politics, most favored nation is a status or level of treatment accorded by one state to another in international trade. The term means the country which is the recipient of this treatment must, nominally, receive equal trade advantages as the most favored nation by the country granting such treatment. In effect, a country that has been accorded MFN status may not be treated less advantageously than any other country with MFN status by the promising country. There is a debate in legal circles whether MFN clauses in bilateral investment treaties include only substantive rules or also procedural protections. The members of the World Trade Organization agree to accord MFN status to each other. Exceptions allow for preferential treatment of developing countries, regional free trade areas and customs unions. Together with the principle of national treatment, MFN is one of the cornerstones of WTO trade law. Most favored nation relationships extend reciprocal bilateral relationships following both GATT and WTO norms of reciprocity and non-discrimination. In bilateral reciprocal relationships, a particular privilege granted by one party only extends to other parties who reciprocate that privilege, while in a multilateral reciprocal relationship the same privilege would be extended to the group that negotiated a particular privilege. The non-discriminatory component of the GATT-WTO applies a reciprocally negotiated privilege to all members of the GATT-WTO without respect to their status in negotiating the privilege. History: the earliest form of the most favored nation status can be found as early as in the 11th century. Today's concept of the most favored nation status starts to appear in the 18th century, which is when the division of conditional and unconditional most favored nation status also began. In the early days of international trade, most favored nation status was usually used on a dual-party, state-to-state basis. A nation could enter into a most favored nation treaty with another nation. With the Jay Treaty in 1794, the U.S. granted most favored nation trading status to Britain. After World War II, tariff and trade agreements were negotiated simultaneously by all interested parties through the General Agreement on Tariffs and Trade, which ultimately resulted in the World Trade Organization in 1994. The World Trade Organization requires members to grant one another most favored nation status. A most favored nation clause is also included in the majority of the numerous bilateral investment treaties concluded between capital exporting and capital importing countries after the Second World War. Benefits: trade experts consider MFN clauses to have the following benefits. A country that grants MFN on imports will have its imports provided by the most efficient supplier. This may not be the case if tariffs differ by country. MFN allows smaller countries, in particular, to participate in the advantages that larger countries often grant to each other, whereas on their own, smaller countries would often not be powerful enough to negotiate such advantages by themselves. Granting MFN has domestic benefits. Having one set of tariffs for all countries simplifies the rules and makes them more transparent. It also lessens the frustrating problem of having to establish rules of origin to determine which country a product must be attributed to for customs purposes. MFN restrains domestic special interests from obtaining protectionist measures. For example, butter producers in country A may not be able to lobby for high tariffs on butter to prevent cheap imports from developing country B, because, as the higher tariffs would apply to every country, the interests of A's principal ally C might get impaired. As MFN clauses promote non-discrimination among countries, they also tend to promote the objective of free trade in general. Exceptions: GATT members recognized in principle that the most favored nation rule should be relaxed to accommodate the needs of developing countries, and the UN Conference on Trade and Development has sought to extend preferential treatment to the exports of the developing countries. Another challenge to the most favored nation principle has been posed by regional trade blocs such as the European Union and the North American Free Trade Agreement, which have lowered or eliminated tariffs among the members while maintaining tariff wars between member nations and the rest of the world. Trade agreements usually allow for exceptions to allow for regional economic integration. Specific countries' policies. United States. In the 1990s, continued most favored nation status for the People's Republic of China by the United States created controversy because of his sales of sensitive military technology. China's MFN status was made permanent on December 27, 2001. All of the former Soviet states, including Russia, were granted MFN status in 1996. On a bilateral level, however, the United States could not grant MFN status to some members of the former Soviet Union, including the Russian Federation, because of the Jackson-Vanik Amendment. This presented an obstacle to those countries' accession to the WTO. At the urging of Vice President Joe Biden, the Jackson-Vanik Amendment was repealed on December 14, 2012. In 1998, in the United States, most favored nation status has been renamed Permanent Normal Trade Relations as all but a handful of countries have this status already. The ideas behind MFN policies can first be seen in U.S. foreign policy during the opening of Japan in the mid to late 1850s, when they were included as a clause in the Commercial Treaty of 1858, which signaled the opening of the Japanese market. Since 1998, the term normal trade relations has replaced most favored nation in all U.S. statutes. This change was included in Section 5003 of the Internal Revenue Service Restructuring and Reform Act of 1998. However, Title IV of the Trade Act of 1974 established conditions on U.S. MFN-NTR tariff treatment to certain non-market economies, one of which is certain freedom of emigration requirements. The Act authorizes the President to waive a counter-Euro unregistered trademark's full compliance with Jackson-Vanik under specified conditions, and this must be renewed by June 3 of each year. Once the President does so, the waiver is automatic unless Congress passes a disapproval resolution. MFN-NTR status for China, a non-market economy, which had been originally suspended in 1951. Was restored in 1980 and was continued in effect through subsequent annual presidential extensions. Following the massacre of pro-democracy demonstrators in Tiananmen Square in 1989, however, the annual renewal of China-Euro unregistered trademark SMFN status became a source of considerable debate in the Congress. And legislation was introduced to terminate China-Euro unregistered trademark SMFN-NTR status or to impose additional conditions relating to improvements in China-Euro unregistered trademark actions on various trade and non-trade issues. Agricultural interests generally opposed attempts to block MFN/NTR renewal for China, contending that several $billion annually in current and future U.S. agricultural exports could be jeopardized if that country retaliated. In China-Euro unregistered trademark's case, Congress agreed to permanent normal trade relations status NPL. 106-286, President Clinton signed into law on October 10, 2000. PNTR paved the way for China-Euro unregistered trademark's accession to the WTO in December 2000. It provides U.S. exporters of agricultural products the opportunity to benefit from China-Euro unregistered trademark's WTO agreements to reduce trade barriers and open its agricultural markets. European Union, the current EU competition law position is that MFN clauses will infringe Article 101(I), if in the individual circumstances of the case they result in an appreciable adversely effect on competition in the European Union. This is likely to happen when the parties to the agreement have substantial market power. It is recognized by EU courts and regulators that such clauses are widely used in a number of industries including most topically with online travel agents. However, the regulatory tide in the EU appears to be turning against the use of these clauses. In a number of recent EU cases in the UK and Germany, MFNs have been condemned when used by companies with significant market power. In January 2014, the UK competition regulator, the Office of Fair Trading, accepted binding commitments from leading online booking platforms, Expedia and Booking.com, to alter the way they operated their MFN clauses with a major hotel chain, International Hotel Group. The decision is being appealed by the price comparison website Skyscanner, and supported by online travel agent, Scoosh. India, MFN status to Bangladesh, and Pakistan. Pakistan had committed in the past that it would grant MFN status to India. However, there are increasing calls in Pakistan to grant the MFN status to China. During the negotiations for the $6.64 billion bailout package from the International Monetary Fund, Pakistan had given an undertaking that it would take positive steps to grant MFN status to New Delhi. In contract law, a most favored nation clause is a contract provision in which a seller agrees to give the buyer the best terms it makes available to any other buyer. In some contexts, the use of such clauses may become commonplace, such as when online e-book retailers contract with publishers for the supply of e-books. Use of such clauses, in some contexts, may provoke concerns about anti-competitive influences and antitrust violations, while in other contexts, the influence may be viewed as pro-competitive. One example where most favored nation clauses may appear is in institutional investment advisory contracts, where if a certain number of conditions are met, one client may be entitled to the lowest fee offered to other clients with a substantially identical investment strategy and the same or lower level of assets under management. See also, Group of 2, National Treatment, Commercial Treaty, Prerogative, References. Further reading, Davey, W.J. Paulin, J.M.F.N. Unconditionality. Incotia, T. Mavroidis, P.C. Regulatory Barriers and the Principle of Non-Discrimination in World Trade Law, Past, Present, and Future. Ann Arbor, University of Michigan Press. ISBN A0472111000. External links, Most Favored Nation Clause, bibliographies on the topics of the International Law Commission, World Bank's MFN Weighted Average Tariff World Level for various products from 2008 to 2012. ITC's Market Access Map, an online database of customs tariffs and market requirements.
The next is national treatment. All right, national treatment is a basic principle that prohibits a discrimination between imported and domestically produced goods with respect to internal taxation and other government regulation. And so I will also play a video for you to watch and get more information on that.
National treatment is a principle in international law vital to many treaty regimes. It essentially means treating foreigners and locals equally. Under national treatment, if a state grants a particular right, benefit or privilege to its own citizens, it must also grant those advantages to the citizens of other states while they are in that country. In the context of international agreements, a state must provide equal treatment to those citizens of other states that are participating in the agreement. Imported and locally produced goods should be treated equally, at least after the foreign goods have entered the market. While this is generally viewed as a desirable principle, in custom it conversely means that a state can deprive foreigners of anything of which it deprives its own citizens. An opposing principle calls for an international minimum standard of justice, a sort of basic due process that would provide a base floor for the protection of rights and of access to judicial process. The conflict between national treatment and minimum standards has mainly played out between industrialized and developing nations, in the context of expropriations. Many developing nations, having the power to take control over the property of their own citizens, wished to exercise it over the property of aliens as well. Though support for national treatment was expressed in several controversial and legally non-binding United Nations General Assembly resolutions, the issue of expropriations is almost universally handled through treaties with other states and contracts with private entities, rather than through reliance upon international custom. National treatment only applies once a product, service or item of intellectual property has entered the market. Therefore, Charging customs duty on an import is not a violation of national treatment even if locally produced products are not charged an equivalent tax. National treatment is an integral part of many World Trade Organization agreements. Together with the most favored nation principle, national treatment is one of the cornerstones of WTO trade law. It is found in all three of the main WTO agreements, GATT, GATS and TRIPS. National treatment is a basic principle of GATT/WTO that prohibits discrimination between imported and domestically produced goods with respect to internal taxation or other government regulation. The principle of national treatment is formulated in Article 3 of the GATT 1947 and incorporated by reference in GATT 1994. Article 17 of the General Agreement on Trade in Services, GATS, and in Article 3 of the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS. The aim of this trade rule is to prevent internal taxes or other regulations from being used as a substitute for tariff protection. A good summary is found in Japan Alcohol, which states, "National treatment obligation is a general prohibition on the use of internal taxes and other internal regulatory measures so as to afford protection to domestic production."
The next topic that I talked about was in relation to unfair trade practices, dumping, subsidies, anti-dumping, countervailing duties, and safeguards. Right? Now, unfair trade practices is to do with, member countries of WTO deciding to being unfair, basically, right? Being unfair to other member countries, and so they come up with practices that sometimes are not fair, all right? And the two main examples of unfair practices in the WTO context are dumping and subsidies, right? Dumping and subsidies. Those are the two main examples of unfair trade practices. Dumping, all right? Dumping is defined in Article 2 of the anti-dumping agreement, okay? What it is that it is defined to mean bringing a product, okay? It is defined to mean bringing a product onto the market of another country at a price less than the normal value of that product. Now, what that means is this. Say, for instance, country A and country B. Country A and country B, they are members of WTO. Now, country A, for some reason, decides to produce surplus of this particular product. Now, this particular product is so much of the so many of these product in the country, and so it's saturated the market, and they decide to sell it elsewhere, and so they export it to country B. Country B is a WTO member. Now, country B is also producing the similar product, but apparently because of country A has so many of this product, it saturated the market. What the country A decide to do is that it sells, all right, the product, right? It sells the single product of that product that has been imported into country B at a price, listen to this carefully, at the price lower than the cost that has been produced, that the product has been produced in the country of export, the exporting country, at the price lower than the cost. All right, that's one. At the price lower than the cost, and at the price lower than what it is sold in the country that is exporting. And then when it is sold also in the country that is importing, it is selling below the price that the country that is producing a similar product, the like product, is selling. So really, when you look at it, it is sold at the low price that slowly over time, right, the country B, all right, the country B industry is unable to cope with the low prices of those goods, and then subsequently this company which is doing this business of selling that product goes out of business, right? there is injury caused, and when it goes out of business, this product, right, being imported into the country, controls the market and is able now to decide what to do, and sometimes it can increase its price and it dominates the market. There is no competition, it dominates the market, and that's when, right, dumping, right, is identified and it becomes unfair, right? It becomes unfair practice so far as the WTO, right, WTO is concerned. The second one is subsidy. All right, second one is subsidy, and subsidy, all right, subsidy also is defined in the countervailing duties article. Now, it is right in its definition. It contains three basic elements: financial contribution, right, by a government on any public body, and it confers a benefit. So the definition of subsidies, right, include these three aspects. Right, all these three elements must be satisfied in order for subsidy to exist. Right, all right. First, it concerns like financial contribution. Right, financial contribution can be in the form of grants, loans, equity infusion. It's to do with government, government buying share in that company, and so government now has equity, as a share in there, and because the government is buying share, government has to support that business, and also government becomes a guarantor of certain loan arrangements that this business tries to go out in terms of borrowing money. Government becomes the guarantor, and government, government purchases goods on behalf of this company, so that the company doesn't spend money, but it's the government's money that is spent in order to support, right? In order to support. So that's a contribution. These are examples in relation to government contribution, right? Government contribution financially to its company, right? Its company or its business to do well. All right. Secondly, in order for financial contribution to be subsidy, it must be made by or at the direction of a government. Normally, it must be directed by government. There is a instruction in place. There is a policy paper in place, or there is a law in place that authorizes government to support, to financially contribute to that company. All right. Financial contribution by a government is not a subsidy unless it confers benefit. So there has to be a benefit, and the benefit is simple, right? The benefit is simple. The company is doing very well. The company is not going out of business. The company is not facing problem. Company is able to compete in another jurisdiction of the WTO member, and also a further benefit is that this company sees, right, it's able to compete and compete well, that the other competitors are not able because they don't have government support. Slowly they go out of business. So what does the WTO say in terms of trying to counter these practices, unfair trade practices? They have come up with countervailing duty and anti-dumping duty. Now these are the two measures that WTO, World Trade Organization, has under the countervailing and anti-dumping agreement under the WTO arrangement, where if a country or a member country is affected by unfair practice by another WTO member country, they could invoke provisions of countervailing duty and anti-dumping duty to offset whatever injuries or whatever unfair practices that they have been confronted with. So I have some videos that I like, another video that I'd like you to listen in relation to unfair business practice, more particularly dumping and then subsidy and countervailing duty and anti-dumping duty.
Hello, my name is Jesse Cryer. I'm a counselor in the Rules Division of the WTO Secretariat, and I'm here to talk to you today about rules in the multilateral trading system governing the provision of subsidies. Now, it's interesting to note that there have been rules about subsidies in the multilateral trading system since its inception. Already the GATT 1947 had subsidies disciplines in Article 16 of that agreement. There was also an Article 6 of the GATT 1947 that provided for the imposition of countervailing measures with respect to subsidized imports. Now, the rules have evolved over time. So, in the 1950s, there were amendments to Article 16 of the GATT 1947, especially with respect to export subsidies. In the 1970s, there was the negotiation in the Tokyo round of an agreement on subsidies and countervailing measures, which was a plurilateral agreement. And then in the Uruguay round, in the late 1980s and 1990s, the members negotiated a multilateral agreement on subsidies and countervailing measures. That agreement is still in effect today, and that represents the existing law. We're currently involved in another negotiation, a new round of negotiations called the Doha Development Agenda. And in the DDA, the members are authorized to negotiate clarifications and improvements to the existing rules on subsidies and countervailing measures. So there have been rules on subsidies since the beginning of the GATT system. Those rules have been in continual evolution and are continuing to evolve. Now, why would we have rules about subsidies in the multilateral trading system? It's certainly not because the multilateral trading system is interested in regulating subsidies per se. To the contrary, the WTO agreement recognizes in a variety of places that subsidies may have a role to play in members' economic and social policies, for example. So the intention is not to prohibit subsidies. However, the members also have recognized that subsidies can have effects on trade, and the rules are intended to speak to those effects on trade. Particularly, the members were concerned that it might be difficult to achieve the objective of progressive trade liberalization if there were no disciplines on the provision of subsidies. Let me give a couple of examples. On the one hand, obviously a central aspect of any trade negotiation is increased market access, the reduction of tariffs, for example. And it's also clear, however, that the provision of subsidies can reduce the value of a tariff concession or even completely negate it. On the other hand, a member who's being asked to make market access concessions to reduce his tariffs may be very reluctant to do so if he believes that his domestic producers will be facing competition from subsidized imports in his market. So in order for members to be comfortable negotiating progressive trade liberalization, it's necessary to have some disciplines on subsidies that speak to the possible effects of those subsidies on trade. Now, let me say a few words about the scope of the disciplines in the Agreement on Subsidies and Countervailing Measures. First, many of you are probably aware that although the multilateral trading rules traditionally dealt only with trade in goods, in the Uruguay round we also negotiated an agreement on trade and services, the General Agreement on Trade and Services, or the GATS. During that negotiation, there was an effort to negotiate specific subsidies rules in the services sector. However, those negotiations were not successful. As a result, the General Agreement on Trade and Services says with respect to subsidies only that it recognizes they may have a distortive effect on trade and services, and it calls on members to negotiate disciplines to address those effects. So the General Agreement on Trade and Services has no specific disciplines on subsidies. The Agreement on Subsidies and Countervailing Measures is an agreement on trade and goods and only applies in that sector. Now, even with respect to the goods sector, there are some limitations on the scope of application of the agreement, and specifically with respect to agriculture. In principle, the subsidies disciplines in the Agreement on Subsidies and Countervailing Measures apply horizontally to all products. But for historical reasons, the development of trade disciplines in the agriculture sector has been both difficult and perhaps in some sense has lagged behind negotiations, for example, with respect to industrial products. In the Uruguay round, there were sectoral negotiations on agriculture with the goal of fully integrating agriculture into the trading system. And the result of that negotiation was an agreement on agriculture. That agreement was a major accomplishment, but the members recognized that it did not fully integrate agriculture into the multilateral trading rules. So in the area of subsidies, the agreement on agriculture has some specific rules about, on the one hand, domestic supports, and on the other hand, with respect to export subsidies. Those rules are, in some respects, arguably more flexible, less constraining than the rules in the agreement on subsidies and countervailing measures. And recognizing that there was need for further negotiations in this area, the members agreed in the agriculture agreement to build an agenda of further agriculture negotiations. And they included a provision in the agreement on agriculture, which is popularly known as the Peace Clause, which provided that for a transitional period, certain measures, including domestic supports and export subsidies that were in full conformity with the agreement on agriculture, would not be subject to certain provisions of the agreement on subsidies and countervailing measures. The idea was to provide time for further agreements in the agricultural sector. But unfortunately, the Peace Clause is now expired, and the members have not yet been able to negotiate new rules. So the current situation with respect to the relationship between the disciplines in the subsidies agreement and those under the agreement on agriculture are somewhat unclear. There is a provision in Article 20 of the agreement on agriculture that says that the multilateral trade agreements, including the agreement on subsidies and countervailing measures, apply subject to the provisions of the agreement on agriculture. Although there has been some dispute settlement in this area and some clarifications provided, the truth is that as of now, we don't entirely understand the legal relationship between the two agreements. But it is important to be aware that it is possible that certain elements of the subsidies agreement disciplines may not, in certain circumstances, apply to the agriculture sector. So, with that by way of background in terms of the history of development of the subsidies agreement and its sectoral application, let's talk a little bit about what those rules on subsidies are. The first question, of course, is what is a subsidy? Now, the term subsidy can obviously have different meanings to different people and to professionals in different disciplines. An economist might interpret the word differently than a lawyer would, for example. So it's quite interesting that although we have had rules on subsidies and reference to the term subsidies in the multilateral trading rules since 1947, it was not until the Uruguay round that we actually had a definition of the term subsidy. That definition is found in Article 1 of the Agreement on Subsidies and Countervailing Measures, and it represents one of the major achievements of the Uruguay round. The definition has, one might say, three components, and I'm putting this in my own words now. It has components relating to the form of the measure. It has components relating to the actor who's taking the measure. And it has a component relating to the terms under which the measure is provided. Those are my words, and I'll now give you a slightly more technical description. I should emphasize, though, first that these are cumulative requirements. Okay, so all three of these elements have to be satisfied in order for a subsidy to exist. Let's talk first about the form of the measure. Under the subsidies agreement, in order for there to be a subsidy, there first has to be a financial contribution in the terms of the agreement. Now, it's clear then that not all government action, even if it confers an advantage, is a subsidy. Only government action that takes the form of a financial contribution has the possibility to be a subsidy. Article 1 has an exhaustive list of the types of measures that can be financial contributions and therefore potentially can be subsidies. I'll give them to you here. The first is direct or potential direct transfers of funds. And these are the types of measures that one might most traditionally think of as subsidies. For example, grants, cash simply given to companies, or loans, loan guarantees, equity infusions, capital infusions of one type or another where a government takes an ownership stake in companies. These are perhaps what one might most traditionally think of as potentially subsidies. But there are several other categories as well. The next one is the foregoing of government revenue otherwise due. The foregoing of government revenue otherwise due is any situation in which the government relieves a company of an obligation to make payments that are otherwise due to the government. So typically, of course, this involves taxes. For example, a company might receive an entitlement not to pay income taxes or an exemption from a sales tax. But it sweeps much more broadly than that. For example, an exemption from import duties can be a financial contribution in the form of the foregoing of revenue otherwise due. Or if a company is permitted not to pay social charges of some kind or another, or is exempted from the obligation to pay unemployment insurance on behalf of its workers, all of these situations might represent the foregoing of revenue otherwise due. Now, beyond this, another category of financial contribution involves the provision of goods or services. This is a situation, quite simply, where the government, for example, provides a service to a company, or the government provides access to goods to a company. Again, either type of transaction is a financial contribution. We'll see that doesn't mean it's necessarily a subsidy because the elements necessary to demonstrate the existence of a subsidy are cumulative. But it is a necessary element that you have a financial contribution in order to have a subsidy. So when the government provides a good or a service, that is a financial contribution and therefore potentially a subsidy. Also the case wherever the government purchases a good. The purchase of a good is a financial contribution which is potentially but not necessarily a subsidy. Finally, the agreement speaks of income or price support, which are terms that are typically used in the context of agriculture. Now, this range of financial contributions sweeps quite broadly, one might say, and that's certainly true. The reason for that is that the definition needs to be sufficiently broad so as to avoid circumvention. A government might find a variety of different ways to provide a subsidy. It can give $1,000 in cash, or it can relieve a company of an obligation to pay $1,000 it owes. Or it can sell the company a product at a price which is equivalent to giving it $1,000. Or it can buy a product at a price which is equivalent to giving it $1,000. We'll talk about these other elements that are necessary in a moment. But the definition is formulated fairly broadly in order to, a financial contribution, I should say, in order to ensure that the governments do not circumvent the subsidies disciplines. That is not to say, however, that all government measures are potentially subsidies. To the contrary, there are certain types of measures that clearly fall outside the list of financial contributions and cannot involve subsidies. For example, when a government provides import duty protection to a domestic producer or a domestic industry, clearly if you're receiving protection in your home market as a result of import duties, that is an advantage for domestic producers. It means maybe they can charge a higher price for their product in the home market. Maybe they'll have a higher market share as a result of the protection. So there's certainly an advantage to being protected by tariffs. But that advantage does not fall within the list of financial contributions that can be subsidies. Why not? I think quite simply because the WTO has very specific rules about tariffs. Every member has a schedule of tariff concessions. So tariffs are dealt with in another element of the WTO agreements. And the members did not want the subsidy rules effectively to swallow the entire package of disciplines. So the subsidies rules do not treat import duty protection as a potential subsidy. So we've seen that the first element of a subsidy is financial contribution. The next element, as I said, has to do with the identity of the actor providing the financial contribution. Now, a financial contribution can be provided by a government or by a public body within the territory of a member. Let's talk about government a little bit. Of course, the government might be the government of the member itself. But it could also be any other government within the territory of the member. For example, a provincial government, a state government, a municipal government, a regional government. All these governments within the territory of the member also have the potential to provide subsidies that are subject to WTO disciplines. So the first element of this actor aspect of the subsidies definition has to do with the range of governments that can provide financial contributions. But in addition, the subsidies agreement speaks of financial contributions by a government or by any public body within the territory of a member. Now, what is a public body within the territory of a member? It must be something beyond traditional government. It could be, for example, an entity created by the government to provide export credits. It could potentially be a state enterprise company which is owned by the government. And I should say here that the precise parameters remain unclear. There are wholly owned government enterprises, there are partially owned government enterprises. There is still not entire clarity about when financial contributions by state enterprises are or are not attributable to governments, and in fact there's currently some dispute settlement taking place on the subject. But clearly financial contributions by state enterprises may, in some circumstances at least, be financial contributions by public bodies within the meaning of Article 1. Finally, there is a provision of the agreement that talks of Article 1 that talks about entrustment or direction by governments to private bodies to provide financial contributions. The intention here, this is, one might say, a form of anti-circumvention provision. And the intention here is to ensure that a government does not provide subsidies through entrustment or direction of a private actor so as to avoid the disciplines of the agreement. So we have to have, in order to have a subsidy, we have to have a financial contribution, and that financial contribution has to be by a government or a public body within the territory of a member. But there is here a third and very important element, which is the existence of a benefit. In order for a financial contribution by a government to be a subsidy, that financial contribution must confer a benefit on the recipient. Now, what does the concept of benefit mean here? Article 1 actually doesn't contain any definition of what a benefit is. But there has been jurisprudence in this area, and it is now quite clear that the concept of a benefit is to be established by reference to the market. And specifically, one looks at the financial contribution by the government and asks whether it's on terms that are more favorable than the terms that would be available to the recipient for the financial contribution in the marketplace. Let's give you a concrete example. Imagine that the government or a government bank provides a loan. Under what circumstances is the loan a subsidy? The loan would be a subsidy if the government was providing it on terms that were more favorable than the recipient could receive if, for example, he went to a private bank. Perhaps a lower interest rate, a more generous grace period. Those are the types of elements one would look at to determine whether the loan conferred a benefit such that it represented a subsidy. Similarly, let's take the advantage of a financial contribution in the form of the purchase of a good. Governments buy goods very often for many legitimate governmental purposes. But if the government is paying an inappropriately high price by comparison with the marketplace, then that purchase of a good can constitute a subsidy. To take an extreme example, if you imagine that the government buys a plastic cup and it pays for that plastic cup $1,000, it should be clear that's not a legitimate purchase by standards of the marketplace, and that the government is in fact providing a subsidy through the purchase. So this basic principle, reference to the marketplace, is the way to establish whether a financial contribution by a government confers a benefit. Now, if we have a subsidy, that still does not mean that the subsidies agreement applies disciplines to the measure, because there's one additional requirement in the subsidies agreement in order for a subsidy to be subject to the disciplines of the agreement. And that is that the subsidy has to be specific. This is Article 2 of the Agreement on Subsidies and Countervailing Measures. Now, what is this concept of specificity? It's actually a little difficult to explain. But the basic idea is that subsidies that are broadly available, widely available throughout an economy, are not subject to challenge under the agreement. And I think the underlying idea here is that governments provide a variety of public goods. So, for example, if a government makes available fire protection services or defense services, educational services, if a government provides access to highways, these are the types of behavior which represent public goods, which if the government makes them available widely throughout the economy, they're not subject to challenge under the subsidies agreement. Another example, imagine in the area of taxation that an economy is in a period of recession or depression. So the government decides to create an investment tax incentive, applicable just for a year, perhaps, to stimulate the economy. So the government decides that for a year's time, people who make investments receive certain tax benefits. But everybody in the economy who makes investments are entitled to them. This might very well be a subsidy within the meaning of the agreement, but because it's widely available throughout the economy, it wouldn't be a specific subsidy, and therefore it would not be subject to the disciplines of the agreement. Now, in general terms, there are four kinds of specificity. A subsidy can be specifically provided to an enterprise or group of enterprises, that is, to specific companies. It can be provided to a specific industry or group of industries, for example, the steel industry or the steel and aluminum industry, just to choose a couple. It can be provided specifically to producers within a particular region, within the jurisdiction of the granting authority. So if a national government makes subsidies available to producers, but only in one particular region of the nation, that would be a specific subsidy. And finally, any subsidy which falls within the definition of a prohibited subsidy, and we'll talk about what those are in a moment, is deemed to be a specific subsidy. So those are the four types of specificity within the meaning of the agreement. So in order for a subsidy to be subject to the disciplines of the agreement, it has to be a specific measure. Now let's assume that we have a subsidy, that is a financial contribution by a government or a public body that confers a benefit on the recipient. And let's assume that that subsidy is specifically provided to a particular company, to a particular sector. What types of disciplines then would apply to these subsidies? Well, as I explained previously, the disciplines of the subsidies agreement are not intended to prohibit all subsidies. They are intended to address the trade effects of subsidies. So we'll see again that the architecture of the disciplines is specifically related to trade effects. In particular, there are two categories of subsidies that are prohibited under the subsidies agreement. And these are two types of subsidies that are specifically designed to affect trade. The first one, and probably the most prominent of the two, is export subsidies. Now, what is an export subsidy? An export subsidy is a subsidy which is contingent in law or in fact upon export performance. Now, obviously, if you provide a subsidy that is contingent upon export performance, it is specifically intended to provide incentives for exports, that is, to affect trade. And it's precisely for that reason that such a subsidy is prohibited. Now, the key here to this definition is the concept of contingency. The subsidy is provided because of actual or anticipated export performance. In other words, it's a subsidy which is provided when you export, but not when you don't export. For example, a government might provide an exemption from income taxes that is limited to income earned as a result of exportation. That would be a subsidy which is contingent upon actual export performance. If you don't export, you don't earn income from those exports, and therefore you don't get any special tax credit. A subsidy can also be contingent upon anticipated export performance. And an example of this would be a situation where the government decides to give an investment incentive, for example, to a company to build a factory. But it makes as a condition for the provision of that investment incentive that the company commit to export a certain proportion of its production. So the subsidy is provided contingent upon the anticipation of exportation. that also would be a subsidy which is contingent upon actual or anticipated export performance and would therefore be a prohibited subsidy. Now, there is in Annex 1 of the agreement a detailed list, an illustrative list, but a detailed list of a variety of export subsidies, which is well worth looking at if you're analyzing a specific case. The second category of prohibited subsidies are what I will call, for the sake of in sort of layman's terms, I'll call them local content subsidies. A local content subsidy is a subsidy which is contingent upon the use of domestic over imported goods. Now, this prohibition is in a sense a codification of an interpretation of Article 3.4 of the GATT 1947 related to national treatment. And the case that it's codifying was a case which is popularly known as Italian tractors. This was the case where the Italian government decided it was going to give subsidies to its farmers so they could mechanize. But in order to qualify for the subsidies, the farmers had to purchase tractors that were made domestically in Italy. They were not eligible for the subsidy if they bought foreign-built tractors. So this is a subsidy which is contingent upon the use, a subsidy to farmers, which is contingent upon the use of domestic, that is Italian tractors, over imported tractors. Now, why would such a subsidy be prohibited? Such a subsidy is prohibited because, like an export subsidy, it's specifically designed to affect trade. Except in this case, it's not designed to promote exportation. Rather, it's designed to displace imports. Now, a common example of a possible local content subsidy today would again be a subsidy, for example, in the form of an investment incentive to build a factory, where a condition for the subsidy was that the producer promises to buy 50%, for example, of his inputs domestically rather than importing them. So that type of subsidy, like an export subsidy, is prohibited because it is designed to affect trade. Now, if a member thinks that there's a prohibited subsidy, its course of action is to request the establishment of a dispute settlement panel through the normal WTO dispute settlement process, consultations, a panel, the possibility of an appeal, etc. And if it is found to be providing a prohibited subsidy, then the panel's recommendation will be that the subsidy has to be withdrawn without delay. Now, what about subsidies that don't fall within these two rather limited categories of prohibited subsidies? All these other subsidies, all these other specific subsidies, are what we call in the WTO system actionable subsidies. Any specific subsidy that is not prohibited is nevertheless actionable. For a subsidy to be actionable means that it can be challenged in the dispute settlement system, but only if the complaining member can demonstrate that the subsidy is causing adverse effects to its interests. Now, by adverse effects, we mean, in some sense, adverse trade effects, if you will. And there are three types of adverse effects specified in the Agreement on Subsidies and Countervailing Measures. So the first and arguably the most important type of adverse effect is referred to in the Subsidies Agreement as serious prejudice. Now, serious prejudice to the interests of another member. Serious prejudice can arise in several different ways. It can arise from what I will refer to as volume effects, or it can arise from what I'll call price effects. Volume effects basically mean lost sales in one way or another. For example, it could be the displacement or impedance of exports from the complaining member into the market of the subsidizing member. I'm trying to sell my product into a country where there are subsidies being provided, and I can't sell the product, or I can't sell as much of it because I'm facing competition from a subsidized product. Or it can be displacement or impedance of my exports into a third country market. In either case, what we're talking about is I've lost some sales, I've lost some trade because of the subsidies. You could also have a volume effect in the form of an increase in the world market share of a primary commodity. So if a WTO member is providing subsidies for a commodity, whether it be cotton or iron ore, it doesn't matter, and if it can be demonstrated that the effect of that subsidy is an increase in the world market share of the subsidizing member, Well, of course, an increase in the world market share for the subsidizing member implies a loss in world market share for others. So that's another type of volume effect, another basis for a serious prejudice claim. But serious prejudice can also be established through price effects. A member can show that subsidies are resulting in price undercutting, that is, that its product is being undersold. A member can complain that a subsidy is resulting in price depression, that is, in order for it to continue to sell its product in a particular market, its prices have to be reduced. A member can complain that the result of another member's subsidies is price depression, or excuse me, price suppression. Price suppression is a situation where the member is trying to sell the product. He should reasonably anticipate he can obtain a higher price over time, but the price doesn't go up precisely because of the effect of the subsidized competition. So these are all different kinds of price effects that can be the basis for a serious prejudice claim. Now, the most difficult part of a serious prejudice claim is perhaps the need to show causation. It's not enough to show that you're losing market share and that there are subsidies, for example, but you have to show that your exports are being displaced or impeded because of the effects of the subsidies. After all, you're complaining about the subsidies. You're not complaining about a change in market share per se. And that can be very difficult to establish. So that's serious prejudice. And serious prejudice can be used by a complaining member when it's concerned about the effects of subsidies on its position in the market of a subsidizing country, or in a third country for that matter, or in the world market. There is a second cause of action, a second type of adverse effect, which is called material injury. In fact, there are three specific types of injury. There is material injury, there is threat of material injury, and there is material retardation to establishment of an industry. In all cases, the scope of this type of complaint is fairly narrow in that it only relates to the effects of subsidized imports. In other words, if you're a member and you want to complain about somebody's subsidies in the context of material injury, the complaint can only arise where subsidized imports are entering into your country. So it's only where subsidized imports are causing material injury to your domestic industry that you can make out an injury claim. And that means, of course, that if the effects are occurring in third country markets, if your export interests are being effective, then material injury is not a cause of action which is available to you. Now, there's a third type of adverse effect under the Subsidies Agreement, which is called the nullification or impairment of benefits accruing under the GATT 1994, and particularly under Article 2 of the GATT 1994. Now, what are we talking about here? Here we're talking about a situation where a member has negotiated market access into the market of another country. As a result of subsidization by that other country, the value of those market access concessions, particularly tariff concessions, has been nullified or impaired. Now, this is a fairly extreme cause of action. It's necessary to demonstrate that the value of the tariff concession is nullified or impaired. Presumably that means very, very substantially reduced or eliminated. But it has been the basis for some successful dispute settlement cases, including a very famous case with respect to soybeans in the 1980s. So those are the three types of adverse effects. So stepping back a moment, if you want to bring a challenge under the WTO Subsidies Agreement, you have to show that there is a subsidy, financial contribution by a government or a public body within the territory of a member that confers a benefit. You have to show that that subsidy is specific. And then you have to demonstrate either that the subsidy is a prohibited subsidy because it's contingent upon export performance or upon the use of domestic overimported goods, or if you can't show that, if you can demonstrate that the specific subsidy is causing one of three types of adverse effects under the agreement. So those are the basis for a challenge of a subsidy under the WTO Subsidies Agreement. Now, earlier on I mentioned that there is a second track available, a second type of mechanism available to address problems arising from subsidies under the WTO agreement. The multilateral track that I've been discussing involves a dispute settlement challenge under the WTO dispute settlement mechanism.
Okay, I think I've come to the end of the second tutorial. I've got one more tutorial that I need to do for your students. That will be done next week with the help of a very helpful gentleman from faculty, George. George has been very kind, and we really, I like to really on record say thank you to him for assisting, taking his time to come and help set up this video and then doing the shooting. This is the first time that I'm able to do this. I've not done that before. I also understand that the students have had difficulties in trying to understand this foreign trade, and that's why I utilized the help of George. Just been very kind. I'm really appreciated. Thank you, George, for your help. So I will do one more tutorial, and that will be the third one that will cover the remaining tutorials that remaining topics that I need to cover before the semester ends. So thank you very much, and I will see you again in the next tutorial number 3. Okay, like we say in Fiji, mode.